All right, welcome back. I've got an interesting one for you today. That's what I'm going to go with is interesting. So, we're headed back to Vegas for Decastro versus Las Vegas Metropolitan Police Department. And I say interesting because I was hoping that after the last video and its aggravation and stupidity that I'd finally be able to get to the long awaited motion to dismiss from the Las Vegas Metropolitan Police Department. Put it off for a week, basically, 8 days. No, a week. Um, Either way, I've put it off because I got distracted by other cases, namely the Boston case and the Schofield case. But I was really hoping to just read a very well written motion to dismiss, which, as I said, I haven't read it yet, but I've heard it's a very good motion. Uh, I'm guessing it's motion to dismiss 12B6 due to qualified immunity, at least primarily qualified immunity. But like I said, I haven't read it yet, so that's just my guess. But yeah, I was hoping to just read a very well written motion and not have the aggravation and bing, bang, boom, be done with it until today. So let's take a peek at the docket as usual. Decastro versus LVMPD. I'm scrolling down. So on June 1st, so it was 8 days ago, we had the motion to dismiss filed by most of the defendants. And then for some reason, I don't know why, it's filed by the same attorney, uh, but the defendant, Jason Torrey, was not included on that motion to dismiss. So basically, on the 7th, same attorney for him filed this motion. I'm not even going to pull it up. It just basically says, me too. It says, defendant Jason Torrey joins in on the June 1st motion. So simple as that. But then today, we had a motion for preliminary injunction by plaintiff Jose Decastro. And it's bad. I mean, I've glanced at it, but just in theory, it's bad. And it's going to require me to actually explain stuff. I mean, I don't like doing work. That's why I do YouTube. But I'm going to have to explain stuff, namely the Younger doctrine, because that explains why this is such nonsense. But let's start with the good, shall we? And jump straight into the motion to dismiss. And it is titled Defendants LVMPD, Officer Bork, Officer Dingle, Officer Sorensen, Officer Sandoval, and Officer Doolittle's motion for partial dismissal. So, defendants LVMPD officer and the officers, collectively LVMPD defendants, and that could be the other officer might be, well, no, because there isn't a Las Vegas or Clark County sheriff. That's why it's the Metropolitan Police Department, not the Las Vegas City Police Department. So never mind. But collectively, LVMPD defendants, by and through their attorneys of record Marquise Auerbach, hereby file their motion for partial dismissal. This motion is made and based upon the memorandum of points and authorities, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of hearing. Memorandum and points of authorities. Introduction. This is a Section 1983 wrongful arrest and excessive force lawsuit. On March 15th, 2023, defendant LVMPD officer Brandon Bork arrested plaintiff Jose Decastro for obstructing a lawful traffic stop when he refused to comply with Officer Bork's commands to move away from the detainee. Notice, it's not for filming. Decastro asserts numerous causes of action under the theory that LVMPD defendants wrongfully arrested him for discriminatory reasons and for exercising his First Amendment right to film. The instant motion seeks dismissal of the majority of Decastro's claims for failure to state a claim upon which relief can be granted pursuant to Federal Rule of Civil Procedure 12b-6. Specifically, the motion requests the court dismiss Decastro's Fourth Amendment and Nevada state law false arrest and false imprisonment claims, first and eighth causes of action, 14th Amendment discrimination claim, second cause of action, First Amendment retaliatory arrest claim, third cause of action, Monell, footnote 1, claim against LVMPD, fourth cause of action, 42 U.S.C. Section 1981 discrimination claim, fifth cause of action, state law invasion of privacy claim, ninth cause of action, state law negligence claim, 10th cause of action. The only claims defendants are not contesting are Decastro's Fourth Amendment excessive force claim, first cause of action, and Nevada state law claims for assault and battery, sixth and seventh causes of action. I'm gonna guess the reason that they're not moving to dismiss here on those two is because we all know the claims are ridiculous, but breaking the habit of a lifetime, he might have pled enough, barely, that if the court takes the facts as true, which is what you've got to do on a 12b-6 motion, you accept the facts as true for the purposes of a motion to dismiss on a 12b motion. So, assuming his facts are true, although they're not facts, but assuming they're true facts, is there enough that you could find for him? So he may have pled enough that, taken as true, you could have excessive force or assault. But all the rest, you can't. I'm guessing that's why. But the others, the first and sixth and seventh cause of action, they'll be dismissed on summary judgment. So it won't go to trial. But and let's take a look. Hey, unlike Delete Lawz, Delete Lawz just said Monell claim. But in the footnote, a good lawyer says, see Monell versus Department of Social Services from the Supreme Court in 1978. And then the statement of facts with footnote 2, which says, for purposes of this motion only, LVMPD defendants assume all facts asserted in the first amended complaint are true, because that's the standard you have to take on a 12b-6 motion. Subject incident. On March 15th, 2023, at approximately 4:30 p.m., Officer Bork was conducting a traffic stop of a silver Hyundai Elantra. Decastro approached the traffic stop and began recording and talking to the traffic detainee. At the time Decastro approached the traffic stop, Officer Bork was sitting in his LVMPD vehicle. Upon noticing Decastro interacting with the subject of the traffic stop, Officer Bork exited his police vehicle, got Decastro's attention, and told him to back up. Decastro moved 5 feet. Officer Bork again told Decastro to back up from the traffic stop, at which time Decastro began asserting his rights to record the interaction. Officer Bork warned Decastro he would detain Decastro for obstructing if he did not move further away from the detainee. Decastro insisted he had no obligation to back up because of his status as a member of the press and his right to record police interactions. When Decastro ignored Officer Bork's commands to move back 10 feet, Officer Bork told Decastro he was being detained. Officer Bork told the traffic detainee she was free to go. When Officer Bork attempted to detain Decastro, Decastro refused to comply. Decastro asked for a supervisor and walked to Officer Bork's LVMPD vehicle, at which time Officer Bork informed Decastro he was being arrested for obstruction. Decastro made Officer Bork aware of a prior shoulder injury, and Officer Bork placed Decastro in 2 pairs of handcuffs to adhere to his medical needs. And we saw that once Artie from Artie's Corporate Fiction, go subscribe to him. He's great. But we saw the videos where he could practically get his hands in front of him. Decastro alleges one of the defendant officers repeatedly squeezed plaintiff's elbow, placing pressure on Decastro's ulnar nerve and causing Decastro severe pain. Decastro then threatened to sue the officers at the scene. Decastro further alleges he was patted down several times, and during the final pat down, an officer struck Decastro in the groin with a closed fist. Eventually, defendant Erland Jason Torrey arrived at the scene. I'm wondering, Erland, I'm wondering if that's a Scandinavian name. I'm betting it is, because I knew people from Sweden by the name of Erlandsson, and going by the Scandinavian naming conventions, I would assume at some point down the line they had a father named Erland. Torrey authorized the officer's behavior as being within LVMPD policy and said Decastro should be arrested. As noted in Officer Bork's report and affirmed by Sergeant Torrey, the reasons why Decastro was arrested was for engaging with a detained driver, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after being advised he was being detained. So not for filming. Wow. Officer Bork's report further stated Decastro had admitted to getting in trouble numerous times in the past for the same reasons, and his habitual behavior of obstructing police officers and claiming it was justified because of his right to film the police would continue in the area if he was not cited. Which is a reasonable theory. I mean, if you don't want to be bothered by him for the rest of your shift, take him to the station. If you have probable cause to do so, of course. Plaintiff's complaint. On April 17th, 2023, Decastro filed the instant lawsuit. It's a bit ironic calling anything an instant lawsuit, considering how long they take. On May 7th, 2023, Decastro filed his first amended complaint as a matter of course pursuant to Federal Rule of Civil Procedure 15A1A. Decastro is suing in his individual capacity, and the lawsuit names officers Brandon Bork, Jason Torrey, improperly identified, C. Dingle, B. Sorensen, Jesse Sandoval, and C. Doolittle as defendants, as well as their employer, LVMPD. The first amended complaint includes the following causes of action. And just while I'm thinking of it, the original complaint, I don't think was properly served. In fact, I'm sure it wasn't properly served. And the first amended complaint he mailed in basically as service of a motion, basically, is how he treated it. So I don't think anyone has been properly served. You'll notice we have nothing from the state of Nevada, although I don't know. I don't remember if he still had the state of Nevada in the amended complaint, but either way, I'd be doing a motion to dismiss for improper service as well as the 12B6, because just get them all in there. So the first amended complaint includes the following causes of action. First claim for relief. 42 U.S. Code Section 1983, Fourth Amendment, false arrest and excessive force against officers Bork, Torrey, Dingle, Sorensen, Sandoval, and Doolittle. Second claim for relief. 42 U.S.C. Section 1983, 14th Amendment, equal protection claim against the officers. Third claim for relief. 42 U.S.C. 1983, First Amendment, retaliation claim against the officers. Fourth claim for relief, 42 U.S.C. 1983, Monell liability claim against LVMPD, Nevada, and Sergeant Torrey. So they do have Nevada still, but like I said, serving or attempting to serve, as the case may be, the Las Vegas Police Department is not serving the state of Nevada. So they're not served yet. Fifth claim for relief. A 1981 claim against officers Bork, Torrey, Dingle, Sorensen, Sandoval, and Doolittle. Sixth claim for relief. Nevada state law assault claim against all defendants. Seventh claim for relief. Nevada state law battery claim against all defendants. Eighth claim for relief. Nevada state law false arrest and imprisonment claim against all defendants. Ninth claim for relief. Nevada state law invasion of privacy claim against all defendants. 10th claim for relief. Nevada state law negligence claim against all defendants. Legal standards. Motion to dismiss standards. A motion to dismiss under Federal Rule of Civil Procedure 12B6 tests the legal sufficiency of the claims asserted in the complaint. The issue on a motion to dismiss for failure to state a claim is not whether the claimant will ultimately prevail, but whether the claimant is entitled to offer evidence to support the claims asserted, citing Gilligan versus Jamco Development Corp. From the Ninth Circuit in 1997. When evaluating a Rule 12b6 motion, the district court must accept all material allegations in the complaint as true and construe them in the light most favorable to the non-moving party. The non-moving party being Delete Lawz. And that's citing Moyo versus Gomez from the Ninth Circuit in 1994. If a plaintiff will not be entitled to relief under any set of facts that could be proven under the allegations of the complaint, the court may sua sponte, that means on its own, dismiss the cause of action or portions thereof, citing Halt versus Wend Invco, I assume that's investments company, from the Ninth Circuit in 1982. Nevada, of course, is a Ninth Circuit state. Relevant 42 U.S.C. Section 1983 legal standards. 42 U.S. Code Section 1983 is not itself a source of substantive rights, but merely the procedural vehicle by which to vindicate federal rights elsewhere confirmed. See Albright v. Oliver from the Supreme Court in 1994. To make out a prima facie, on its face, to make out a prima facie case under Section 1983, a plaintiff must show that a defendant, 1, acted under the color of law, and 2, deprived the plaintiff of a constitutional right. See Borunda versus Richmond, Ninth Circuit, 1989. The defendant officers do not dispute that they acted under the color of law. Of course not. They're police officers and they were acting within the scope of their job. Therefore, the task of this court is to determine whether the defendant officers violated the Constitution. See Albright, which was the Supreme Court case cited above. In addition, the defendant officers have raised the affirmative defense of qualified immunity. Hey, pretty good guess on my part, wasn't it? A defendant in a Section 1983 action is entitled to qualified immunity from damages for civil liability if his conduct did not violate clearly established statutory or constitutional rights of which a reasonable person would have known, citing Harlow v. Fitzgerald, a Supreme Court case from 1982. And it's funny how many times has Delete Lawz screamed, qualified immunity isn't the problem, Terry versus Ohio is the problem. James Freeman is an idiot because qualified immunity isn't the problem, Terry v. Ohio is. The officers aren't claiming Terry versus Ohio here. They're claiming qualified immunity. Fun, isn't it? The Supreme Court has often stressed the importance of deciding qualified immunity at the earliest stage possible in litigation in order to preserve the doctrine's status as a true immunity from suit rather than a mere defense to liability, citing Hunter v. Bryant, a Supreme Court case from 1991. Because what kind of immunity is it if you have to still go to trial to defend yourself only to find out, no, he had qualified immunity? It's not an affirmative defense. It's a shield from litigation. In determining whether an officer is entitled to qualified immunity, a court considers, 1, whether there has been a violation of a constitutional right, and 2, whether that right was clearly established at the time of the officer's alleged misconduct. So the question is there a clearly established right for anyone to interact with a detained person at a traffic stop? No, there isn't. Therefore, qualified immunity. I mean, I remember back in 2002, I was a senior in high school, and there were worries that Yellowstone was going to ban snowmobiles altogether. So my family took a trip up to make sure that we got to snowmobile through Yellowstone at least once, because it's magical in the winter. And my cousin, who was 16 at the time, was pulled over in the park by a park ranger for basically being reckless on his snowmobile. And his mother was worried about her minor son and went to, be present at his traffic stop, because that's what it is, a traffic stop. The park ranger said, "Get lost. This doesn't involve you." Now, if they can do that to the mother of a minor driver, they can certainly do it to an unknown party interfering. So, finding my place. Consequently, at summary judgment, a court can only deny an officer qualified immunity in a 1983 action if the facts alleged, taken in the light most favorable to the party asserting injury, show that the officer's conduct violated a constitutional right and that the right at issue was clearly established at the time of the incident, such that a reasonable officer would have understood his conduct to be unlawful in that situation. Citing Torres versus City of Madera from the Ninth Circuit in 2011. So it's not just that your rights were violated; it's that a reasonable officer had to have understood at the time of the arrest that it was unlawful. So basically, if there's vagueness about whether or not you can interact with a detained driver, qualified immunity, dismissed. Legal argument. A. 42 U.S.C. Section 1983, Fourth Amendment and state law fails arrest for first and eighth causes of action. Decastro is alleging the defendant officers violated his Fourth Amendment rights and Nevada state law rights by arresting him without probable cause. Accepting the allegations in Decastro's complaint as true, Decastro's false arrest claims fail as a matter of law because it fails to state a claim upon which relief can be granted. And we go on to the relevant false arrest law, because you've got to go on the clearly established law at the time of the arrest. The Fourth Amendment prohibits unreasonable searches and seizures. See U.S. Constitution. Well, it's the Fourth Amendment. Not quite sure what that 8 is for, but okay. To determine whether an officer had probable cause for an arrest, courts examine the events leading up to the arrest and then decide whether these historical facts, viewed from the standpoint of an objectively reasonable officer, amount to probable cause, citing District of Columbia versus Westby from the Supreme Court in 2018, which itself quoted Maryland versus Pringle, also from the Supreme Court in 2003. It requires only a probability or substantial chance of criminal activity, not an actual showing of such activity. Once again, I've said this before multiple times. Not today, but multiple times. It requires an arrest, requires probable cause or a substantial chance of criminal activity. It does not require showing actual criminal activity. What does that mean? It means even if in his criminal case, which we're going to get to later because it's, but even if he's not convicted, even if they dismiss, they've got incentive not to dismiss because, hey, he sued. So it just makes it a whole lot easier to win this if they win the criminal case. But even if he's not convicted, that doesn't mean he wins the civil rights case because he's got to show there was no probable cause. Probable cause is a lower standard than preponderance, and preponderance is anything above 50%. So you take a scale and it's exactly at 50%, you put a grain of sand on the other side and there's the preponderance met. So probable cause is lower than that, and reasonable suspicion is even lower than that. So they just have to show there was probable cause to arrest him. And just what I just said, probable cause is not a high bar. All that is required is a fair probability that crime occurred, citing Garcia versus City of Merced from the Ninth Circuit in 2011. If the facts known to the arresting officer are sufficient to create probable cause, the arrest is lawful, regardless of the officer's subjective reasons for it, citing Tatum versus City and County of San Francisco from the Ninth Circuit in 2006. So, what does that mean? That means if, as long as they had probable cause to arrest, let's say they normally wouldn't have arrested someone in that situation, but because Delete Lawz was a jerk and the officers didn't like him, that doesn't matter. There was probable cause, so they were allowed to arrest. And see also Devin Peck versus Alford from the Supreme Court in 2004, which says the subjective reason that an officer arrests a suspect is irrelevant so long as the available facts suggest that the suspect was committing a crime. Hey, that's a better way of saying what I just said. They arrested him for the subjective reason that he was a jerk and they wanted to get him out of the way so he wouldn't interfere on the rest of their shifts. The objective reason they arrested him is because they had probable cause that he committed the crime of obstruction. The subjective reason does not matter. The mere existence of some evidence that would suggest a defense or non-involvement in the crime would not negate probable cause, citing Yusefian versus City of Glendale, 9th Circuit, 2015. The probable cause analysis is the same whether under federal law or Nevada state law. See Marshall versus City of Carson from the Nevada Supreme Court in 1970. when the underlying facts claimed to support probable cause are not in dispute, whether those facts constitute probable cause is an issue of law. See, I assume it's Ornelas versus United States from the Supreme Court in 1996. So it's an issue of law, meaning it's for the judge to decide. And I think the reason they're bringing this up, the reason they're saying that the subjective reason is irrelevant, the probable cause, the subjective reason is irrelevant as long as there was probable cause, we're good. It's because Delete Lawz is trying to allege racial animus. But as long as there's probable cause, they could arrest him. Sorry. Officer Bork had probable cause to arrest Decastro for obstruction. And this is an easy argument for them to make because Delete Lawz, his well-pleaded facts, and I say well-pleaded very sarcastically, but his well-pleaded facts that must be taken at true at this point are, he's alleging they arrested me for filming, for being a journalist, for engaging in my First Amendment right. And but they're saying, well, even if that's the case, we still had probable cause to arrest you for obstruction. So even if our subjective reason was arresting you because we didn't like being filmed, you were still obstructing. Therefore, we win. Generally, police officers have the right to control bystanders at the scene of police activity. If a bystander refuses an officer's lawful orders, probable cause exists to arrest for obstruction. See Spencer versus Rao from the Western District of Texas in 2007, which says probable cause existed to arrest a bystander attempting to help at a traffic accident after the bystander ignored multiple requests to return to his car. And also Abrams v. Walker from the Northern District of Illinois in 2001, where a trooper had probable cause to arrest and prosecute an attorney for obstruction, and a traffic stop did not constitute retaliation against the attorney for exercising First Amendment rights when an attorney parked a vehicle and walked up to personally voice his concerns about a stop's legality because attorney's actions prolonged a stop for 20 minutes. So an attorney who, I'm assuming it wasn't his client, but interfered and was arrested for interference. Him being an attorney didn't shield him from liability. And in fact, this could actually get him in trouble with the bar because, I mean, I know attorneys have a reputation as being ambulance chasers, but actually being an ambulance chaser is a real good way to get disbarred because there's, like, for a long time, attorneys weren't even allowed to advertise, period. But there's still real strict advertisement rules. And one of them is you can't directly solicit people. And that could be directly soliciting someone on the side of the road at a traffic stop. And that could be very bad. I certainly wouldn't do it. The First Circuit in Garrick versus Begin In addressing the First Amendment right to film police officers during a traffic stop, stated that police officers may place reasonable restrictions on bystanders during traffic stops when circumstances justify them. That's a First Circuit case from 2014 that also says police officers may have justifiable reasons to prevent bystanders from filming a traffic stop. So the First Circuit says, you know, there may be situations where we can just prevent you from filming the traffic stop altogether. Not just, hey, don't interact with our detainee, move back. Here, Officer Bork was the only officer on scene and the person most familiar with the dangers of individuals inserting themselves into traffic stops. The following facts are undisputed. Officer 1. Officer Bork noticed Decastro approaching the traffic stop and interacting with the subject of the traffic stop. 2. Officer Bork told Decastro to distance himself from the traffic stop. 3. Decastro only backed away 5 feet and remained in a position close enough to interfere. 4. Officer Bork warned Decastro that Officer Bork would detain Decastro if he would not back up further. And 5. Decastro claimed he could stand next to the traffic stop and film and refused to comply with Officer Bork's order to move a safe distance away. All Officer Bork was attempting to accomplish was to control the scene and ensure the safety of himself and the subject of the traffic stop by separating Decastro from the scene of the traffic stop. Further, the traffic detainee never asked to speak with Decastro, and because she was detained, was unable to avoid his filming of her and attempting to talk to her. As admitted in the first amended complaint, Decastro ignored Officer Bork's multiple reasonable requests and through both action and word made it clear that he intended to interfere with the traffic stop based upon his flawed understanding of the First Amendment and the public's right to record police interactions. The Ninth Circuit has held that under Nevada Revised Statute 197.190, it is obstruction to impede and prolong an investigation. See Tsao versus Desert Palace, Inc. from the Ninth Circuit in 2012. Further, Nevada district courts have held that an individual is obstructing when the individual is given several opportunities to comply with defendant's orders, but fails to do so, citing LVMPD Kelly versus LVMPD, a Nevada state court case from 2014. And that's going to carry great weight because, hey, a Nevada state court case saying this is what obstruction is in Nevada, it basically puts a reasonable officer on notice of what obstruction is in Nevada. That's the clearly established rule. Based upon the totality of the circumstances, Officer Bork had probable cause to conclude that Decastro was hindering and delaying the subject traffic stop. Decastro was very clear that he was not going to follow Officer Bork's orders and that he had a right to be there, just feet away from an active traffic stop. Such conduct constitutes obstruction. See Rao. Thus, Decastro's arrest was based on probable cause and no constitutional violation occurred. At a minimum, Officer Bork is protected by qualified immunity on Fourth Amendment false arrest claim and discretionary immunity on the state law false arrest claim. Fourth Amendment claims, assuming arguendo, meaning assuming for the sake of argument, Officer Bork lacked the requisite probable cause to arrest Decastro. The next issue is whether the law regarding his unconstitutional activity was clearly established. So basically, what he's saying here is, let's assume for the sake of argument that the officer violated Delete Lawz rights. We still have to establish whether that violation of his rights was of a clearly established right at the time of the arrest. In other words, even if his rights were established, that action had to have been clearly established as unconstitutional at that time. The court can't say right now, yes, we are finding that this was unconstitutional, and we are finding that right now for the first time, therefore Delete Lawz wins. They can say, going forward, we find that this is a violation of the Constitution. This is now the clearly established rule. Then next time someone is arrested under the same circumstances, they can say, hey, the court found, that it's a clearly established rule because in the Decastro case, they found blah, blah, blah. So that is, at the time the arrest occurred, was the constitutional violation sufficiently clear that every reasonable official would have understood that what he was doing violated that right? Citing Matos versus Agorano from the Ninth Circuit in 2011. A court should conduct this analysis by examining the most analogous case law that existed when the incident occurred. Therefore, the issue is whether on March 15th, 2023, it was clearly established that it would be unconstitutional for an officer to arrest an individual for obstructing when the individual unilaterally thrust himself into the middle of a traffic stop and refused multiple orders to stand off to the side while an officer performed the traffic investigation. That was a long sentence. I have no problems with it, just saying it was a long sentence to read. In 2009, the Ninth Circuit in Lassiter versus City of Bremerton, Washington is also in the Ninth Circuit, addressed a Washington state obstruction arrest where a potentially violent husband refused to sit down during a domestic violence investigation. And once again, that's Lassiter versus City of Bremerton from the Ninth Circuit in 2009. In addressing the obstruction charge, the Ninth Circuit found the undisputed facts are sufficient to conclude that the officers had probable cause because the husband refused to sit down for safety reasons, and this made it impossible for the police to carry out their duty. He said duty. The Ninth Circuit addressed another obstruction arrest in Gravelet Blondin versus Sheldon in 2013. In that case, the plaintiff was a bystander to the arrest of his neighbor. When the plaintiff was within 37 feet of the police activity, he was told to get back and stop. The plaintiff froze but was still tased. After being tased, the plaintiff was arrested for obstruction. Now, in this case, is 37 feet reasonable? Probably not. Meaning, Delete Lawz. Is requiring 37 feet from a traffic stop reasonable? Probably not. Of course, there are some frauditors out there that are so loud and disruptive that it might be. Because you saw above where they said the totality of the circumstances indicate that arrest was appropriate. The totality of the circumstances in Shelton probably we don't know yet, but he was a bystander to the arrest of his neighbor. I'm guessing that might have been a domestic violence charge. If it's an arrest of a violent subject, hey, 37 feet is probably more than sufficient. I mean, just recently, I didn't watch this whole video because I found the guy insufferable, but the auditor, I think his name is Sheepdog, was arrested because he wouldn't leave a crime scene where basically they were in a standoff with someone with a gun. And even though it was down the block, the officer said, "You're on our secure crime scene. You need to leave." And he refused. "Well, you don't have tape, so I can be here." And they arrested him. Of course, they gave him a lot of chances to leave, but they arrested him. And rightly so. But once again, it's the totality of the circumstances. If you're in a standoff with an armed subject, you're going to have a bigger perimeter than if you're conducting a traffic stop with a cooperative woman who's, driving 5 over the speed limit. Of course, if the cop saw Delete Lawz had a 45 on his hip, he could have said, "You can film, but you're standing 30 feet away and within my line of sight, not behind me." That would have been reasonable. The Ninth Circuit held that because the plaintiff followed the officer's commands to not approach and did not interfere in the officer's duties, issues of fact precluded summary judgment in favor of the officers. A year before Gravlett-Blondin, the Ninth Circuit addressed the Nevada statute at issue in this case and found that it is obstruction to impede and or prolong an investigation. That's citing Sow, the Nevada, or Ninth Circuit case, sorry, Sow. And also Rao, Sow and Rao, and Kelly, which says, probable cause to arrest under NRS section 197.190 when an arrestee ignores multiple commands from the officers. Thus, based upon the above case law, in March 2023, the constitutionality of an obstruction arrest turned on whether 1. The potential for violence exists, 2. The arrestee is warned to stop his obstructing, and 3. Whether he complies with that order. Here, it is undisputed that Officer Bork gave Decastro multiple opportunities to move a safe distance from the traffic stop. There is no clearly established law that would have informed Officer Bork otherwise, and thus dismissal is appropriate. As to the state law claims, with respect to the state law false arrest claim, the defendants are immune from liability from the state law claims on the basis of discretionary function immunity pursuant to NRS 41.032. C. Gonzalez versus Las Vegas Metropolitan Police Department from Nevada court in 2013, which held that an officer's decision to arrest based on a matched description in a facially valid warrant was entitled to discretionary immunity. So basically, what that's saying is, hey, we arrested the actual subject of the warrant's doppelganger. That's not a false arrest because it was reasonable that, hey, it matches the picture, but it was his identical twin or whatever. That's not false arrest, though, because a reasonable officer looks at the picture and says, hey, that's him. In Gonzalez, the Nevada Supreme Court evaluated the application of the discretionary immunity doctrine in evaluating the officer's decision to arrest and detain a suspect. In Gonzalez, the court found that LVMPD's decision to arrest or detain Gonzalez based on a warrant was part of a policy consideration that required analysis of multiple social, economic, efficiency, and planning concerns, including public safety. Once again, citing Gonzalez, which itself cites Martinez versus Marushak from 2007. See also Santiago versus Massachusetts Department of State Police from the District of Massachusetts in 2013, which says, officers' decisions regarding investigation and when to seek warrants for arrests are based on considerations of public policy. The court also observed that the imposition of liability against LVMPD may jeopardize the quality of governmental process. As a result, the defendants are not subject to liability for Decastro's claims of negligence and false imprisonment. Plaintiff's 42 U.S. Code Section 1983 14th Amendment Equal Protection Claim, the second cause of action. Relevant 14th Amendment law. To state a Section 1983 claim for violation of the Equal Protection Clause of the 14th Amendment, a plaintiff must allege that the violation was committed with an intent or purpose to discriminate based upon plaintiff's membership in a protected class. Lee versus City of Los Angeles, 9th Circuit, 2001. To prevail on a selective enforcement claim, the plaintiff must show that enforcement had a discriminatory effect and the police were motivated for a discriminatory purpose, citing Lacey v. Maricopa County, 9th Circuit, 2020. Where the challenged governmental policy is facially neutral, proof of its disproportionate impact on an identifiable group can satisfy the intent requirement only if it tends to show that some invidious or discriminatory purpose underlies the policy. So what that means is basically, sure, the name Decastro is Hispanic sounding, even though he doesn't appear Hispanic. So when they stopped him, until he identified, which I don't think happened until after he was under arrest anyway, so he wasn't arrested for discriminatory purposes anyway. But even if, as long as the obstruction law wasn't written to target Hispanic people, hey, you're golden. If the action does not involve a suspect classification, a plaintiff may establish an equal protection claim showing that similarly situated individuals were intentionally treated differently without a rational relationship to a legitimate state purpose, citing Village of Willowbrook versus Olek, a Supreme Court case in 2000. To state an equal protection claim under this theory, a plaintiff must allege that 1. The plaintiff is a member of an identifiable class. 2. The plaintiff was intentionally treated differently from others similarly situated. And 3. There is no rational basis for the difference in treatment. And those factors come from Oleg. Analysis of Decastro's 14th Amendment claims. Decastro alleges the officers arrested him based upon the color of his skin, his position as a member of the press, and his viewpoints. First, Decastro never asserts he was discriminated based upon his unknown race, only that he believes he was arrested due to the color of his skin. He has not identified any similarly situated individuals who share the color of his skin who were not arrested or cited for obstructing a traffic stop. This conclusory statement is insufficient to survive a motion to dismiss. We all know Delete Lawz is Captain Conclusory. Further, he does not identify what press agency he belongs to, and regardless, the press is not a protected class. And he cites Ashcroft versus Iqbal. You've heard me cite Iqbal many times. That's the Supreme Court case from 2009, which says, you've heard me say this exact quote many times, threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. '42 U.S.C. Section 1983 First Amendment retaliation, third cause of action. Relevant First Amendment law. The Supreme Court has held that a plaintiff must show the absence of probable cause to maintain a retaliatory arrest claim under the First Amendment, and that absent such a showing, a retaliatory arrest claim fails. Unless the plaintiff fits into a narrow qualification for circumstances where officers have probable cause to make arrests, but typically exercise their discretion not to do so, citing Neves versus Bartlett, Supreme Court, 2019. A plaintiff falls within the exception to the no probable cause requirement for a retaliatory arrest claim under the First Amendment, where he presents objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. Has he shown that other people interfering in a traffic stop and refusing to stop interfering weren't arrested? No. But that's not even a First Amendment claim, because you don't have a First Amendment right to interfere in a traffic stop. Analysis of Decastro's First Amendment retaliatory arrest claim. Decastro was arrested for obstructing Officer Bork's traffic claim when he chose to involve himself in the stop, talk to the detainee, and then refused to move back to an area where he could not interfere. As discussed supra, meaning above, probable cause existed for the arrest. According to Decastro, he was arrested for protesting his arrest. Thus, his argument is simply that he was arrested for protesting his lawful arrest. That's circular. Decastro has not identified any other individuals who protested their own lawful arrest and were then not arrested. Thus, he has failed to allege prima facie facts supporting a First Amendment false arrest retaliatory arrest claim. I like that argument. 42 USC Section 1983, Monell and supervisor liability. Fourth cause of action. Plaintiff's fourth cause of action is a municipal liability claim against LVMPD and Sergeant Torrey. This federal law municipality claim is commonly referred to as a Monell claim. See Monell versus Department of Social Services, Supreme Court, 1978. Relevant Monell legal standards. It's funny how Delete Lawz didn't really sufficiently cover what Monell is or its standards. He just listed allegedly bad practices by the LVMPD. In Monell, the court held that when a municipal policy of some nature is the cause of the unconstitutional actions taken by municipal employees, the municipality itself will be liable. See Monell. And that's it. He just laid out a list of a conclusory list, might I add, a speculatory conclusory list of supposed policies of the LVMPD. So liability only exists where the unconstitutional action implements or executes a policy statement, ordinance, regulation, or decision officially adopted and promulgated by municipal officers, or where the constitutional deprivation is visited pursuant to governmental custom, even though such a custom has not received formal approval. Citing Monell. The court defined custom as persistent and widespread discriminatory practices by state officials. Still citing Monell, which cited Adikes versus S.H. Dress & Co. from the Supreme Court in 1970. The doctrine of respondeat superior does not apply to 42 USC 1983 claims against municipalities. Oh. Pembauer versus City of Cincinnati, Supreme Court, 1986, citing Monell. That's a problem for Delete Lawz because, hey, even if an officer violated his laws, respondeat superior doesn't apply, so their supervisor doesn't. At the very least, their supervisor isn't on the hook, period. Unless they were on scene and violated their rights. In other words, municipal liability is not established merely by showing that a municipal employee committed a constitutional tort while within the scope of employment. So, and supervisor and the city itself, there, no liability. For liability to attach to a municipality, a plaintiff must establish that the wrongful act complained of was somehow caused by the municipality, citing Monell. Such liability can be imposed only for injuries inflicted pursuant to a governmental policy or custom, citing Monell. In addition, there must be shown to be an affirmative link between the policy or custom and the particular constitutional violation alleged, citing City of Oklahoma City versus Tuttle, Supreme Court, 1985. The alleged policy or custom must be the moving force for the constitutional violation in order to establish liability under Section 1983, citing Polk County versus Dodson, Supreme Court, 1981, which cites Monell. Causation must be specific to the violation alleged, meaning that merely proving an unconstitutional policy, practice, or custom however loathsome, will not establish liability unless the specific injury alleged relates to the specific unconstitutional policy proved. Citing Board versus County of Commissioners of Bryan City, Oklahoma versus Brown, Supreme Court, 1997. And looking at other cases, I like the wording of this. Unless the specific injury alleged relates to the specific unconstitutional policy proved. Why do I bring that up? Think to the Massachusetts case, the copyrights. How many times in covering that have I said, at a bare minimum, like even ignoring fair use and registration of the copyrights and all that, all the other requirements and defenses, just at a bare minimum, to adequately plead a copyright claim, you have to say this specific video from the defendant violated my copyright in this specific work because. And he's never done that. Here, he has not alleged that this specific injury relates to this specific unconstitutional policy of the LVMPD. And sorry, this specific proved policy of the LVMPD. He has a great list of speculative policies of the LVMPD. They're not proved. That he doesn't have, hey, they did this in this case, and this case, and this case, and this case, that proves a pattern of conduct that satisfies Monell, or it's written down here, therefore it's a official policy and it's unconstitutional, therefore Monell. So he fails. Once each of these elements are met, a plaintiff must further prove that the unconstitutional policy that caused him injury was the result of something more than mere negligence on the part of the municipality, and was instead the result of deliberate indifference, a state of mind that requires a heightened level of culpability, even more than mere indifference. That sounds an awful lot like the Monell equivalent of actual malice required for a defamation claim. In fact, the Monell standard for municipal liability has been interpreted as more restrictive than common law restrictions on private employers' liability for punitive damages. See David Jacks Achtenberg, Taking History Seriously, Municipal Liability under 42 U.S. Code Section 1983, and the debate over respondeat superior from the Fordham Law Review in 2005. Now, that's obviously a law review article, so it's not controlling law, but it is a scholarly work on the subject that cites, I'm sure, the history and practices of interpreting Monell. So it's a very persuasive argument. Proof of a single incident is insufficient to establish a custom or policy. Once again, citing Tuttle. To properly plead a Monell claim against LVMPD, a plaintiff must 1. Identify the challenged policy or custom. 2. Explain how the policy or custom is deficient. 3. Explain how the policy or custom caused the plaintiff harm. And 4. Reflect how the policy or custom amounted to deliberate indifference, i.e., show how the deficiency involved was obvious and the constitutional injury was likely to occur. Citing Harvey versus City of South Lake Tahoe from the Eastern District of California in 2012. Post-Iqbal, remember the Ashcroft versus Iqbal above that we've cited so many times. So after Iqbal, a plaintiff cannot rely on conclusory factual allegations. Rather, a plaintiff must allege facts which, if true, show that the defendant actually had a constitutionally impermissible policy, practice, or custom. Citing Waggy versus Spokane County, Washington, 9th Circuit, 2010. An actionable policy or custom is demonstrated by 1. An express policy that, when enforced, causes a constitutional deprivation. Baxter v. Vigo County School Corporation, 7th Circuit, 1994. 2. A widespread practice that, although not authorized by written law or express municipal policy, is so permanent and well settled to constitute a custom or usage with the force of law. Citing City of St. Louis versus Praprotnik, Supreme Court, 1988, which is a plurality opinion. Wow, you don't get a whole lot of those. A plurality opinion. Or 3, constitutional injury caused by a person with final policy-making authority. The description of a policy or custom and its relationship to the underlying constitutional violation, moreover, cannot be conclusory. It must contain specific facts. That's a problem for Captain Conclusory. That's citing Spiller versus City of Texas City Police Department from the 5th Circuit in 1997. Existence of a policy without more is insufficient to trigger local government liability. Citing Oviatt versus Pierce, 9th Circuit, 1992. Analysis of Decastro's Monell claim. First, if the court has already concluded that the officers did not violate any of the plaintiff's constitutional rights, then the Monell claim fails as a matter of law. See City of Los Angeles versus Heller from the Supreme Court in 1986, which says, if a person has suffered no constitutional injury at the hands of the individual police officer, the fact that the departmental regulations might have authorized the constitutional violation is quite beside the point. So basically, even if there's a unconstitutional policy, if your constitutional rights weren't violated, the constitutional policy is irrelevant for the purposes of whether or not your constitutional rights were violated. Funny that. Second, Decastro has not identified a specific policy or practice. Instead, Decastro pleads conclusory allegations of the existence of unconstitutional customs, policies, or practices relating to LVMPD's methods of handling individuals that obstruct traffic stops. However, there is no identification of a policy that, when enforced, caused the alleged constitutional violation. See Baxter by Baxter versus Vigo County School Corporation, Ninth Circuit in 1994. Decastro instead generally pleads LVMPD trains its officers to carry out unlawful detentions and arrests. However, Decastro's conclusory assertions are belied by the factual allegations within the first amended complaint, namely, that the LVMPD defendants violated LVMPD's formal use of force policy and interactions with the public policy. Decastro has failed to plead facts demonstrating any of the following. 1. An express policy that, when enforced, caused a constitutional deprivation. 2. A widespread practice that, although not authorized by written law or express municipal policy, is so permanent and well settled to constitute a custom or usage with the force of law. Or 3. Constitutional injury caused by a person with final policy-making authority. Therefore, Decastro has failed to adequately plead a specific policy or practice, and Decastro's Monell claims must be dismissed pursuant to Federal Rule of Civil Procedure 12b6 accordingly. Moving on, USC Section 1981 discrimination claim. Fifth cause of action. And first we have Section 1981 law. Section 1981 prohibits discrimination in the making and enforcement of contracts by reason of race, national origin, or ancestry. Since this isn't the making or enforcement of a contract, it fails. In order to establish a claim under Section 1981, a plaintiff must allege facts in support of the following elements. 1. Plaintiff is a member of a protected class. 2. Plaintiff attempted to contract for certain services. And 3. Plaintiff was denied the rights to contract for those services. CEG, Lindsay versus SLT Los Angeles, LLC, from the Ninth Circuit in 2006. In addition, to survive a motion to dismiss for failure to state a claim, a plaintiff alleging a Section 1981 claim must allege overt acts coupled with some direct evidence that the defendant's conduct was motivated by animus against the protected class. See Evans versus McKay, Ninth Circuit, 1989. Indeed, mere knowledge of plaintiff's ethnicity, coupled with a conclusory assertion of discriminatory animus for defendant's action, does not create a plausible inference necessary to survive a 12b6 motion. Citing Jehan Zeb Mir versus State Farm Insurance, Central District of California, in 2019. Analysis of Decastro's 1981 claim. Here, Decastro's first amended complaint does not allege Decastro was attempting to contract with any defendant for certain services. Moreover, Decastro does not allege he is a member of a protected class. Rather, Decastro merely alleges that he was discriminated against because of the color of his skin, political affiliation, and viewpoints. Nevertheless, even taking Decastro's allegations as true and drawing reasonable inferences in his favor, Decastro has failed to allege a 42 U.S.C. Section 1981 claim upon which relief can be granted because Decastro was not attempting to contract with defendants for any service and was not denied the rights to contract for any service. I mean, this is spaghetti pleading. It's throwing spaghetti against the wall and seeing what sticks. throwing allegations against the wall, see what sticks. Unfortunately for him, that 1981 wasn't even spaghetti. It was a rutabaga. State law invasion of privacy claim, 9th cause of action, and the law on the invasion of privacy. Nevada's common law recognizes the tort of invasion of privacy for unreasonable intrusion upon the seclusion of another. The purpose of the tort is to provide redress for intrusion into a person's reasonable expectation of privacy, citing Clark County School District 5 versus Las Vegas Review-Journal, Nevada 2018. You'll notice right away it's unreasonable intrusion into a person's reasonable expectation of privacy. This isn't Fourth Amendment standard. This is state common law. So it's not, did you have the right under the Fourth Amendment to conduct a search? That's completely different from state common law tort of invasion of privacy. The tort of invasion of privacy embraces 4 different tort actions. A, unreasonable intrusion upon the seclusion of another, or B, appropriation of the other's name or likeness, or C, unreasonable publicity given to the other's private life, or D, publicity that unreasonably places the other in a false light before the public. And that's citing the Restatement Second of Torts, Section 652A from 1977, and PETA versus Bobby Barosini, LTD, from Nevada in 1995. So the unreasonable publicity given to the other's private life. Sounds to me that when frauditors engage in call flooding, at least, like if they were to say, Officer Bork arrested me, this is his home phone number, don't call, that call flooding might be invasion of privacy under the Nevada invasion of privacy common law tort. Analysis of Decastro's invasion of privacy claim. Decastro alleges the defendants intentionally invaded and intruded into plaintiff's personal and private affairs by searching his belongings without a warrant or other legal justification. According to Decastro's facts, he was searched and transported to the Clark County Jail. Thus, according to Decastro's first amended complaint, he was simply searched as a result of his arrest. Thus, legal justification existed for Decastro's search. See United States versus Robinson, a Supreme Court case from 1973, which held that that search incident to an arrest based on probable cause is reasonable and requires no additional justification. Hey, if that's reasonable, then scrolling up, it can't be unreasonable. And a person can't have a reasonable expectation not to undergo a reasonable search incident to arrest. Because that wouldn't make sense. Moving on to the 10th cause of action, state law negligence. Decastro's state law negligence cause of action alleges the officers breached the standard of care by negligently arresting him. As set forth above, probable cause existed to arrest Decastro, and therefore the claim fails on that basis alone. Additionally, the defendants are statutorily immune from this claim because determining whether to arrest an individual is a discretionary act protected by NRS 41.032. See Ortega versus Reyna from Nevada in 1998, which concludes that no civil liability attached to a state trooper's decision to arrest a driver for allegedly refusing to sign a traffic ticket because the decision to do so was a discretionary decision requiring personal deliberation and judgment and was, thus, entitled to immunity under NRS 41.032 sub 2. And Cody versus Washoe County, a Nevada case from 1992, which says the decision of whether to make an arrest is largely discretionary. Conclusion. LVMPD defendants bring the instant motion for partial dismissal because Decastro has not pled facts sufficient to state a claim upon which relief can be granted for the following claims. 1. 42 U.S.C. Section 1983 Fourth Amendment false arrest and imprisonment claim. 2. Nevada state law false arrest and imprisonment claim. 3. 42 U.S.C. Section 1983 14th Amendment claim. 4. 42 U.S.C. Section 1983 First Amendment claim. 5. 42 U.S.C. Section 1983 Monell claim, municipal liability claim. 6. 42 U.S.C. Section 1981 intentional discrimination claim. 7. Nevada state law invasion of privacy claim. And 8. Nevada state law negligence claim. Based on the foregoing, LVMPD defendants respectfully request the court grant the instant motion and dismiss aforementioned claims. Dated this first day of June 2023, Marquis Auerbach, signed by Craig Anderson. And it was served by ECF upon Delete Lawz. Yikes. And by yikes, I mean that was a well-written motion. I was hoping it would be, and it was. Unfortunately, this next one will not be. It's gonna be a mess. Because we have here Delete Lawz emergency motion for preliminary injunction to stay state proceedings. He's trying to get a stay in the criminal case. And for some reason, he has his emergency contact information in here. I mean, that might be in a local rule for an emergency injunction. And he does include his email. Obviously, do not email him. And by that, I actually do mean don't email him, not the frauditor. But really don't email him. But for some reason, he says, phone doesn't usually work. Sorry, even though I'm not going to scroll up, but in the box above, right there, he does have his phone number. I think this is him being petulant about Blue Bacon being hesitant to give his phone number in the Los Angeles case because Delete Lawz has been known to abuse Blue Bacon's phone number. Plaintiff Jose Decastro, plaintiff, hereby moves this honorable court to hear his emergency motion pursuant to Local Rules 7-461D and Federal Rule of Civil Procedure 6C1C to grant plaintiff's motion to stay pursuant to 42 USCS Section 1983 and Federal Rule of Civil Procedure Rule 65. The state criminal proceedings on the claims in this action that are brought under 23 CR, the case number of his criminal case, the first hearing of which is set to be held at 8 a.m. on June 13th, 2023, at the Justice Court, Las Vegas Township, Clark County, Nevada. And a quick plug for our Nevada judges, who is going to record that. They are not going to be able to live stream it because Hammer Boy objected, because even though he says film all court proceedings, he doesn't want his filmed, but our Nevada judges is filming it and uploading it to YouTube later, so obviously go watch it on our Nevada judges and just, subscribe to our Nevada judges and watch their videos, because Alex does a very good job. And the hearing on June 13th is merely his arraignment. Basically, the judge says, this is what you're charged with. How do you plead? Guilty or not guilty? Delete Lawz, being Delete Lawz, either won't show up, or he'll probably, if he does show up, make a scene. But otherwise, it really is an easy hearing. He's freaking out about it, though, as shown by this motion. This emergency motion is made because of the timing of the criminal action on June 13th, 2023, that will chill plaintiff's rights. Plaintiff had expected his internal affairs complaint to have been completed, but the LVMPD's own delays have led us here. It's my understanding, as I've said before, I don't watch his videos, but I saw on Discord today, on the Chili Watch Discord, he did a live stream at the Internal Affairs, LVMPD Internal Affairs, where they informed him that his internal affairs case was closed. No action taken. So, yeah. And it's almost like they don't work on his timeline, nor are they answerable to him. But he says this motion is made because of the timing of the criminal action on June 13th. It's been 3 months. It took 3 months to get to arraignment in that case. That's slow. He wants it delayed even more. But the timing of the criminal action, he thinks the timing of the criminal action is the problem pending the outcome of the civil case. He's got it backwards. The civil case has no meaning until the criminal case is decided, at a minimum. In support of this motion, plaintiff submits a memorandum of law, which is fully incorporated herein. Facts. Plaintiff was illegally arrested by defendants while exercising his civil rights in violation of his civil rights pursuant to 42 U.S.C. Section 1983 and in retaliation of plaintiff's exercise of his civil rights. That's not true. You were not illegally arrested. Plaintiff was cited for 1. false statement to or obstruct police officer or public officer, NRS 197.190, and 2, resisting public officer, NRS 199.280.3. Defendants do not contest plaintiff's claims of excessive force in their motion for partial dismissal, ECF number 15. Plaintiff expects excessive force to continue to be used against him if he is jailed awaiting trial in retaliation for plaintiff asserting his rights, First Amendment rights, in violation of 1st, 4th, 8th, and 14th. That is... That wasn't me stumbling over that sentence, by the way. Plaintiff expects excessive force to continue to be used against him if he is jailed awaiting trial, comma. In retaliation for plaintiff asserting his rights, First Amendment rights, and in violation of his 1st, 4th, 8th, and 14th Amendment rights. Funny story. Remember how a couple videos ago I said this was going to be relevant? And I was actually referring to the motion to dismiss, but I didn't get to it. But then I brought it up in reference to Google in the Massachusetts case. And I mentioned a motion to dismiss is not an answer. It comes before the answer. So when Delete Lawz says defendants do not contest plaintiff's claims of excessive force, that's true. They're not contesting anything in the motion to dismiss. They're contesting whether or not he has stated claims upon which relief can be granted. There's a difference. Remember, in an answer, what you have to do is you have to go line by line and admit or deny or say, I don't have enough information. I have no knowledge. Every line, you've got to admit or deny. And failure to deny means you admit. And I think that's where sovereign citizens and frauditors get the idea that in anything, failure to respond is acquiescence. So, I sent you my fee schedule, you didn't respond, therefore you agreed to it. Even though that's complete nonsense. But for the purposes of an answer to a complaint, failure to respond or failure to deny is an admission. But that's on an answer. He's trying to hold the standard of an answer to a motion to dismiss. So because they didn't move to dismiss the excessive force claims, that obviously means they don't contest it. Which means they're admitting excessive force, according to Delete Lawz. But that's not the case at all. That just means what they're saying is, hey, we think he's probably pled enough that it survives 12b6, so we're not going to ask for it because what's the point? But what they're going to do is that they're going to move for summary judgment. And on summary judgment, they'll win. It's not going to go to trial. He's not going. Delete Lawz will not win. And but what that means is we're going to get a ruling on the motion to dismiss. Chances are it's granted. The other two claims that they didn't include in their motion to dismiss, they're going to have to answer, and then we'll move on. But he seems to think it means they're admitting it here, when that's far from true. And he expects excessive force to continue if he is jailed awaiting trial. Well, number one, why is he expecting to be jailed awaiting trial? He was released without bond. No, he didn't. As far as I know, he didn't have to pay money to get out. So at an arraignment for a low-level misdemeanor, because let's face it, he's acting as if this is a capital crime that he's defending. It's a low-level misdemeanor. It's I mean, he's got to take it seriously, but it's not the end of the world if he loses. But unless he misbehaves and is jailed for contempt of court, why does he expect to be jailed awaiting trial? Because he won't be unless he misbehaves. And the officers wouldn't be his jailers anyway. It would be entirely different people. It's ridiculous. Defendants now claim additional offenses in their motion, page 1, line 28, related to obstruction at a traffic stop, even trying to cite non-existent facts in plaintiff's complaint where no traffic stop is alleged. They are able to allege facts too. They are able to say, these are the facts. Is he a moron? That was rhetorical, by the way. Defendants raise in their motion only irrelevant cases where members of the public were not exercising their constitutionally protected rights and were in fact causing unsafe situations or inserting themselves into investigations. Plaintiff was exercising his free speech in recording the police and challenging the police's requests to protect the driver's privacy, completely unrelated to safety. Defendants even make outrageous claims in their motion that discrimination based on the color of plaintiff's skin is not illegal discrimination under the 14th Amendment. They're saying that's not what happened. Plaintiff only talked to the driver when the officer was in his vehicle and moved back to an area out of the way when the officer left his vehicle. Plaintiff in no way participated in any obstructive behavior beyond the assertion of his rights to free speech. See Duran versus City of Douglas, Arizona, 9th Circuit, 1990. I mean, does he seriously think that in the irrelevant cases cited by the defendants, Does he seriously think, well, if only those defendants had been filming, then they couldn't have been arrested? Because a camera is a shield from arrest. Absolute immunity as long as you're filming. Because I've got news for you, sunshine. That's not how it works. This court is the proper forum for plaintiffs' claims where the threat of a criminal prosecution under a state law that violates the First Amendment won't chill plaintiffs' civil rights, especially as charges have not yet been brought. Citing Dombrowski versus Pfister from the Supreme Court in 1965. Additionally, a malicious prosecution will further harm plaintiff and lead to supplemental claims being added to this action. Memorandum of Points and Authorities. A. Plaintiff exercising his clearly established right to free speech is not obstruction or resisting. Citing Duran. But interfering with the traffic stop is. Plaintiff had the clearly established First Amendment right to record police. See Fordyce versus City of Seattle, Askins versus U.S. Department of Homeland Security, and Ford versus City of Yakima. You were not arrested for recording police. They never told you to stop recording. They told you to stop interfering and to move back. Plaintiff has the right to not be harassed based on his viral... Let's see if I can get that out this time. Plaintiff has the right to not be harassed based on his viral videos criticizing the police. See Addison versus City of Baker City. And this federal district court has the authority to stay an action that chills plaintiff's civil rights, especially as charges have not yet been brought. See Dombrowski versus Pfister. No. Besides which, he was cited. He has an arraignment. That's where the charges are read. Why would he have court if charges have not been brought? Riddle me that. Why would he have court? Why would he need an injunction against court for charges that have not been brought? It's ridiculous. Conclusion. Plaintiff prays for this court to grant an order or orders for 1. The Justice Court, Las Vegas Township, Clark County, Nevada, to stay proceedings under the criminal case number until the instant action is finalized. But that doesn't make sense. He's saying, I want you, federal court, to order the Justice Court for Clark County to stay the proceedings in the criminal case until the civil case is finished. So I want you to wait until the federal court has decided whether the arrest was valid which a condition precedent to that is at a minimum winning the criminal case. So basically, the federal court would have to say, if they stayed the criminal proceeding, they'd have to say, hang on, hey, Justice Court, we need your ruling on this so that we know whether there's any reason to continue with this civil case. But like I've said, even if he wins the criminal case, that doesn't mean he wins the civil case. It just means it wasn't beyond a reasonable doubt. It doesn't mean there wasn't probable cause. And that is what he has to prove in the civil case. But if it was beyond reasonable doubt, there was obviously probable cause, so he wins, or he loses. Vegas wins. So, and here strategically for Delete Lawz, this is why this is colossally stupid of him. It's colossally stupid. Generally, you want a criminal case decided before a civil case, because in the criminal case, you're generally going to plead the Fifth Amendment, your right to remain silent, your right against self-incrimination. You do not have a Fifth Amendment right against self-incrimination in a civil case. So either, if the civil case went forward first, either he takes the stand and pleads and testifies, and that's held against him in the criminal trial, or he pleads the Fifth because it can incriminate him. But then there's an adverse inference against him in the civil trial, and those questions are deemed as admitted. An adverse inference is drawn. So it just makes it easier for Vegas to win the civil case. Now, normally, these 1983 cases aren't the conclusion of. Where this usually comes up is, my internet is acting up, but where this usually comes up is, let's say, a securities fraud case. Let's look at Sam Bankman-Fried right now. He has civil cases brought by the Securities and Exchange Commission, the CFTC, and private parties. And he has a criminal case brought by the Southern District of New York. So, what does he want to go first? He wants the criminal case to go first because he's going to plead the Fifth. And then, if he wins, he goes to the SEC case and the CFTC case, and number one, he says, look, the federal court found me not guilty, so you should find that I didn't commit civil securities fraud or commodities fraud, or but also he can testify without it being held against him in the criminal case. But Delete Lawz has it backwards. It's ridiculous. It's stupid. And aside from that, in this case, it's not how it works. because one more filing, then we'll get to the educational bit. So normally this is kind of a nothing. The meet and confer certification, local rule 7-4, in support of plaintiff's emergency motion for preliminary injunction to stay state proceedings. Normally, this is nothing. It's a truism. It's, I certify that I met and conferred with opposing counsel before filing this motion. But instead, we have Delete Lawz saying, plaintiff Jose Decastro contacting opposing counsel several times regarding this motion, specifically emailing back and forth with Craig R. Anderson. Anderson was actually surprised to hear that the criminal complaint proceeding was still going on. Anderson simply indicated that if the criminal proceeding was still going on, which he didn't think it was, that he would be moving to stay the federal proceedings instead of the opposite. Because that's how it works. I mean, Attorney Anderson probably at this stage hasn't even looked at the criminal proceeding, because why would you bring the civil rights case before the criminal case has even been decided if charges are pending? I mean, he probably should have, but it just doesn't make sense to bring the case first anyway. So he went with the motion to dismiss. And he's saying, hey, thanks for the information. I should probably bring a motion to stay instead, which, you know, that this was brought today, or, well, I guess yesterday, but showed up on Pacer today. Although I guess now that's also yesterday, since it's gone past midnight here. Although it's not. It's still Friday in Vegas for 12 more minutes, so we'll go with that. But expect on Monday or Tuesday or whenever, real quick, for the defendants to submit a stay motion for the civil case, saying, hey, the criminal case is still going. Let's stay this until the outcome of that, because if he's found guilty, this is all irrelevant anyway. And why is that? Why is that? I told you we'd have to do some work and actually be educational. So this is a handy website. It's not Wikipedia. It's Wiki Law School. And this is a handy Section 1983 litigation abstention doctrines. And this is very well written. I could hardly put it better myself. So I'm just going to read some of it and give my commentary on that. So, reading it, even though a federal court has subject matter jurisdiction over a Section 1983 action, it may decline to exercise that jurisdiction if the case falls within one or more of the abstention doctrines. These abstention doctrines are intended to apply in relatively narrow circumstances. The Supreme Court has described a federal court's obligation to adjudicate claims properly within its jurisdiction as virtually unflagging. Accordingly, abstention from the exercise of federal jurisdiction is the exception, not the rule. And the court has limited the circumstances appropriate for abstention. The major abstention doctrines in a 1983 action are Pullman, Younger, Colorado River, and Burford. The domestic relations doctrine has been raised in some Section 1983 actions, but much less frequently than the other abstention doctrines. The Tax Injunction Act normally bars federal Section 1983 actions contesting state and local tax policies. For our purposes, Younger applies, but we'll take a brief look at Pullman as well, because this is the Pullman abstention state certification procedure. So under Pullman abstention, named after Railroad Commission of Texas versus Pullman Co., a federal court may abstain when the contested state law is ambiguous and susceptible of a state court interpretation that may avoid or modify the federal constitutional issue. So, what's that? Basically, the state law question is obstruction. If the obstruction law were vague, the state of Nevada has an interest in defining, narrowing the scope, interpreting the vagueness of their state law. So the Nevada state court gets to determine the interpretation of Nevada state law. They get to determine the vagueness of Nevada state law, not the federal court in a civil case. So if the obstruction law were vague, the Nevada state court gets to decide. Does this apply to the Nevada, does this specific situation, does interfering with a traffic stop constitute obstruction under Nevada state law? That would be the Pullman abstention. But we are more interested in the younger abstention. So, reading, the most frequently invoked abstention doctrine is in Section 1983 actions is the Younger abstention, named after the leading case of Younger versus Harris. Younger abstention generally prohibits federal courts from granting relief that interferes with pending state criminal prosecutions or with pending state civil proceedings that implicate important state interests. The Younger doctrine espouses a strong federal policy against federal court interference with pending state judicial proceedings. It is based primarily on principles of federalism that require federal court non-interference with state judicial proceedings. Need I say more? We have a state criminal proceeding. The state of Nevada has an interest in prosecuting said state criminal proceeding. Under federalism, a federal court cannot interfere in that state criminal proceeding. They will not interfere in that state criminal proceeding. Thus, they're not going to rule. Well, first off, they're not going to stay that criminal proceeding. But it also, they're not going to rule, especially in Delete Lawz' favor, until after that state proceeding, because if they find, well, we find at the federal level that there wasn't even probable cause, therefore, it certainly couldn't be beyond reasonable doubt, so case dismissed. That's interfering with the state proceeding. Done. At a minimum, the best Delete Lawz can hope for is that the civil case in federal court is stayed until after the criminal proceeding. Anderson said if he knew the criminal case was still ongoing, he would be moving to stay the federal proceeding instead of having the criminal case stayed. End of story. And with that, I think we've learned enough for today. So, thank you once again for joining me. Oh, it's amazing how I can spend just as much time on Delete Lawz 4-page motion as on a good attorney's 19-page motion. So, with that, please do all the YouTube-y things, like, share, subscribe, and I will see you very soon for the next one, I'm sure. Bye-bye.